What is DPDP?
Think of it as the one piece of law that tells you how companies are allowed to process your data, what rights that you have in relation to this data against those companies, and how can you really help enforce these rights against those companies. This law is the complete code that talks about all of these aspects. The classic example that I think is discussed here is there was some time ago a torch app that required access to your contacts, required access to your financial information, required access to your dating history and so on. But now I think they would be required to show that whatever they collect is actually necessary to enable a torch function.
Advocate Thomas is a leading expert on India's Digital Personal Data Protection Act, and he comes with a deep experience in data privacy and technology law. He joins us today to break down the act.
As a result of deciding whether the Aadhaar is a valid scheme or not, the courts had to decide whether Indian citizens had a right to privacy.
I post a picture of mine on a social media app. There's another individual account on the same platform that takes my picture, does a deep fake of it and puts it out.
Yeah.
Now, how does the Protection Act or the privacy laws apply in this scenario? What rights do I have as a user currently residing in India?
This is a complicated one, Supreet, only because I think
Hello everybody, welcome to another episode of Tech Talks. I'm Supreet from AIM Network. Folks, day in and day out, the tech that we use is improving on an exponential level. But if there's one thing that all of us are still concerned about or skeptical about is how all of these entities and organizations hold, preserve and maintain our data. And of course, as all of you are aware, in the news is India's DPDP Act since the last few months. But if you were to download the PDF, there's a lot of nuances, there's a lot of information that it's probably difficult to read and interpret for the average man like you or me. So to debunk all of these laws, to give you a good clarity of all of the nuances that are involved, join with me is a lawyer who's been practicing in this arena since quite a long time. And he's going to answer some of the most common questions, misconceptions and myths that all of you and me have about the DPDP Act. So let's welcome Thomas to the podcast. Thank you, Thomas, for joining in. I hear you are the DPDP expert since quite some time. So, yeah.
Thanks, Supreet. Thanks for having me. This is, I like to tell the story of my career in terms of how many versions of the DPDP bill we've now finally had and now eventually the Act. So it's great to now actually finally have a law that I can talk about and that I can help, your audience to kind of understand and make better use of.
Right.
Thanks for having me over.
Right. So, Thomas, you've advised countless companies on the policy, on the Privacy Act. So, just to set the right context, what is DPDP, if you were to frame it to someone who extensively uses internet apps day in and day out?
Nice question, Supreet, to start off with. And I think the way I would think about this is think of it as the one piece of law that tells you how companies are allowed to process your data, what rights that you have in relation to this data against those companies, and how can you really help enforce these rights against those companies. This law is the complete code that talks about all of these aspects. As a company, think of it as essentially a set of outcomes that the government wants you to achieve in relation to data protection, and basically a set of principles that you have to follow in your operations going forward. So in sum and substance, it's like outcomes that the government wants you to achieve and a set of rights that you as an individual have against companies.
Right. Now, before we even proceed to how private companies are going to abide by the law, let's talk about the government first, because our data is out there with a lot of government digital applications, be it Aadhaar, or DigiLocker, or DigiYatra. So, firstly, how does the entire policy exempt the government, in ways they access or abide by the policies or regulations that are there, or where is it mandatory even for a government institution to abide by some of the regulations of the DPDP Act?
So, Supreet, I think one of the key things to kind of understand when we talk about government's use of data is that, at least with respect to the government, there are a series of laws that they are subject to, which talks about how they can handle data. But at least as it pertains to this particular law, there are a number of exemptions in terms of what the government can do or can avail in relation to your data. So, for instance, if you have to provide your data to the government to avail a subsidy or a benefit, potentially they can do that without your consent.
Okay.
Right? Or if there is data that the government needs to investigate an offense that you've committed,
Okay.
potentially they can do that without consent or without complying with most of the provisions of this act. But having said that, there is a large body of Indian case law as well as other laws. For instance, under the Criminal Procedure Codes of India, the Information Technology Act of India, as well as a number of case laws that the Supreme Court has from the 1960s until, almost earlier this year, has laid down where there are procedural safeguards that the government has to abide by when they process your data. So even though there are some leeways that are granted to the government under this, I'm not as skeptical about what is the use of by the government of this data. I think there is a healthy kind of jurisprudence or laws that exist in India that prevent the government from overtly misusing your data.
Okay.
And grant you, the citizen, some rights at least in relation to this. But yes, could it have been better under this act? Of course. But yeah, I think this is the status that we are in right now, and I think there are ample methods for us to be able to even hold the government to account in terms of what it can do with its data.
Right. And now coming back to the apps that me, you, and the audience use on a regular basis, we got the AI apps, on so many social media apps on our phone that are really data hungry and probably have every single information about us, from cookies or the information that we enter. So what tangible differences that we will observe going forward once the act is implemented by these companies?
Got it. So before I jump into the question on apps, maybe for the benefit of the audience, I'll give like a 1-minute summary of what the act does and what its key principles are. I think you'll see it as a recurring theme through our conversation. The first and extremely key idea is that this act applies to something called personal data. Now, personal data is any piece of data that identifies you as an individual. Very easy examples would be your mobile number, right? Or let's say your Aadhaar number, right? Or any government identifier that identifies you, the individual. Now, there could also be information that associated with other pieces of information could become personal. So, for instance, if I had, let's say, your salary information, or I had your let's say I had your address, right, and I combined it with your name, it could essentially become personal information because the combination of those two pieces of information is able to identify you, the human individual, right? So this law applies to personal data and the processing of personal data by both companies and the government. Now, what are the principles that this law lays down? The first key principle is that every person or every entity that's processing your data must have a legal basis to do so. That is, it must establish that one of the conditions under the law is met out. There are two possible conditions that you can establish under the law. One is they've taken your consent to process that data, that is with your permission. Or alternatively, there's something called a legitimate use under the act, which is, let's say, for instance, you walk into a hospital and you're, in an emergency situation. Clearly, at that point in time, it's almost impossible to get your consent to process your personal data in order to give you medical treatments, right? Similarly, and I think this is a classic example that's provided in the act itself. Let's say you provide your phone number to a pharmacy for the pharmacy to give you a bill. For the sole purpose of giving you the bill, the pharmacy isn't going to ask you for consent because you have voluntarily provided that information to the pharmacy. So these are the kinds of purposes which do not require consent. But by and large, every organization that's processing your information requires your consent to do so. Now, in order for them to obtain your consent, they have to give you something called as a notice, which is, loosely speaking, describing what they do with this information, what information they collect from you, and what can you do to address any complaints or grievances that you have in relation to this data. So as a result of which, what it allows you to do is it basically gives you an informed perspective of what each organization can and will do in the future with respect to your data. So that's largely the basic principles by which an organization can process data. But you as a citizen also are conferred certain rights under the act. For instance, you can go to an organization and say, give me a summary of all of the personal data processing activities that you take in case with respect to me. So, for instance, next time you get an annoying, pesky call from a real estate telemarketer who's asking you, whether you want to buy a flat, very legitimately you can approach that organization and say, look, tell me about how you have my personal information and give me a summary of how you obtained this personal information.
Okay.
Secondly, you can ask organizations to delete personal data that they have with you. Okay. Now, again, the same example, like if you don't want to be bothered by a specific telemarketer, or you don't want to be bothered by a specific agency that is calling you for commercial communication, you can reach out to them and say, look, please delete my personal data. Then there are abilities for you to correct your personal information available with organizations. A classic example of this is, let's say you've provided inaccurate information for, by way of a mistake or so to a financial institution, and they're unable to process a transaction for you. You can reach out to them and say, look, this is my accurate pieces of information. The other bits are more reactive sort of rights that you have. For instance, if your data gets hacked, the organization is required to inform you within a certain timeline that your organization, that your data has been hacked. It's also required to inform the government that they have been hacked in relation to that specific data. So very broadly speaking, these are the basic principles that, the Act requires organizations to do. Now, coming back to your question on social media apps and so on, right? Every organization that processes your personal data is required to meet these requirements. So potentially now you have very granular personal data notices that will be provided to you to enable you to know what the organization is doing with your data, what sort of rights do you have, who can you reach out to in case you have certain issues with the way that your data is processed. As a result of which, I think consent screens are going to be more prevalent in your life, right? Now, even though they were already long documents to begin with, potentially now they're going to be even longer because I think they're required to be granular under Indian law. And the other advantage that you have under the new law is that now, earlier it was an all or nothing thing. There would be a bucket of list of purposes where you had to say yes to all 100 if you wanted to use a particular social media app. But now you have the option to opt out of certain individual pieces of processing. Right? The classic example that I think is discussed here is there was some time ago a torch app that required access to your contacts, required access to your financial information, required access to your dating history and so on. But now I think they would be required to show that whatever they collect is actually necessary to enable a torch function. And it also allows you to opt out of providing certain pieces of information to a specific piece of app. So I think the way I see it is that social media apps and other organizations that are doing data intensive businesses should be ready to grant a little bit more control to users in the way that they're processing data. They need to be aware of what they're doing and what the interface they have with the specific users are and how they can kind of encourage a compliant use of their data. But at the same time, I don't think the government is looking at this law as an overly prescriptive set of do step 1, step 2, step 3, step 4, step 5, etc. I think what they're looking for this is to set out a set of principles or outcomes that you want to achieve as a government. For instance, you need to ensure that people have rights, right? Or you need to ensure that people are informed about what their data is, how their data is being processed. All of these things, I think, are the outcomes that they want to achieve, and you as an organization have some flexibility in terms of how you achieve these outcomes. So I think in that sense, where the law has landed up after nearly, I would say, a 14-year journey to get here is, I think, a good happy middle between protecting kind of interests in some way, whereas allowing organizations some flexibility and some breathing room to be able to kind of process or implement compliances in their own fashion. So what will change? More control, definitely a more conscious processing of personal data, and hopefully a culture of rights that are enforced against these organizations.
So it's mostly about giving users, asking users the additional consent and just keeping their rights, at the highest level of priority. So you also mentioned that it's been a 14-year journey. So you could shed light on the story, or if there was any particular case or a legal battle that ignited this spark towards the government creating a DPDP Act.
So please, I can talk about this for hours, but I'm just going to try and keep it limited. So I just had a few crucial milestones, I think, in India's privacy jurisprudence, and I don't think we give our courts enough credit for some of this stuff. The first case law that recognized privacy in India was in 1964.
1964, okay.
Yeah, which was even kind of before the Indian digital revolution. There was a case called Kharak Singh versus, I think, the state of Uttar Pradesh, if I'm not mistaken. We had another one in the 1970s, Gobind against state of Madhya Pradesh, which also recognized the right to privacy. In the 90s, in the late 90s, once the broadcasting media became a lot more prevalent in India, written word became a lot more prevalent in India. We had a whole slew of, and actually also the other prominent landmark case on this was on wiretapping of telephones, right? So once telephones penetration became common in India, there was a whole range of cases in the late 90s, which also again recognized kind of the right to privacy. The only thing was that I think these were all operating in the fringes. I think the executive or the government itself was slow to catch up with what principles the courts were engaging with. So there was no law at that point in time. India's first IT law in that sense, even though we've had a telecom law for nearly 150 years now, first IT law came in 2000, right?
Yes.
But even that did not, or at least had very scanty principles on how personal data was processed. Then, because of the outsourcing boom that existed in India in the late 90s, early 2000s, in 2008, thankfully, the government had amended, the law to bring about what it calls the protection of sensitive personal information. Right. And then 3 years later, government seems to operate in 3-year cycles here as well. 3 years later, the government brought out these set of rules called the sensitive personal data rules, essentially. Now, these rules protected, sensitive personal information, which was sexual orientation, medical history, financial records, your passwords, your biometrics, those kinds of very sensitive pieces of information. And kudos for the Indian government recognizing sexual orientation as a piece of sensitive personal information all the way back in 2011, before it was even decriminalized. So I think there's a whole range of kind of that history that traversed all the way up to 2011. We were also influenced a lot by international developments in this front. So there was an OECD set of principles that came out in the 1980s. The European GDPR was also, I think, the first version of it was, a few years in at that point in time. So we've taken influence from some of these principles and laid down something kind of basic. But I would say until this law was actually enacted, the enforcement or the compliance culture around it was not so well developed, right? Because even though the government has enacted this law, it didn't really enforce it. I think I can count on my fingers the number of cases where people have proceeded against companies under this kind of SPDI rules or the sensitive personal data rules, probably sub 10, maybe 20 at most, right? And I'm talking about a 14-year long history right now. So as a result of which, I think civil society groups, various tech groups as well in the country felt the need for something a little bit more concrete. And if we had to become a real mature digital economy, I think this was a key component of our infrastructure. Regulatory infrastructure is also a key component of our infrastructure. So the law is a key component of our infrastructure. I think we've had the first version of this act come out in 2011, right? That was an early draft. There was a few kind of iterations that came up in between. And then I think the key pivotal moment was the Aadhaar case in the Supreme Court. So in, I think, 2016 or so, there was, or slightly earlier, there was a gentleman by the name of Justice Puttaswamy, who's from Karnataka actually, who challenged the constitutional validity of the Aadhaar scheme. And this is one of the judgments where I've had the opportunity to be involved in the early parts of my career. So it was like a great learning experience for me as well. As a result of deciding whether the Aadhaar is a valid scheme or not, the courts had to decide whether Indian citizens had a right to privacy. Right. So even though various judgments had already laid down shades of it earlier, for the first time that the court is consciously faced with the question of, do our citizens have the right to privacy? And in a landmark judgment in 2017, there was a categoric holding that given that we all have the right to life and liberty, we all have the right to make autonomous decisions about our person, and our person includes the information that you and I generate as individuals. So that is really the genesis for this serious attempts into making kind of like the personal data protection law. So 2017, we had that judgment. Shortly after the Aadhaar judgment itself came out in 2018, there was a Justice B.N. Sri Krishna committee report that was issued just after that kind of judgment came out, which laid down the basic principles for what the law must contain. And since then, we've had a few iterations of the bill. 2018, we had one. 2019, we had one. Subsequently, I believe in 2021 also we had one. But 2023 is when we finally had essentially like the version of the act that we see right now passed in its form. So we've traversed essentially, I think, I would say a 60-year journey almost to get to where we are right now. And thankfully, in that 60-year journey, I think we've come to a place where we've drawn a happy middle between, trying to be overly protective of our industries, but also at the same time ensuring that, our citizens get kind of the rights that they are entitled to under our laws.
Right. So from what I understand is that before DPDP was enacted or even laid down, privacy cases or privacy measures or the rules and regulations were subjective to an individual case when it was taken to court, right?
Yeah.
Right.
So in order to enforce rather the rules that existed between 2011 and actually they still continue until 2027, is that you had to go to a body called the adjudicating officer, who is an officer appointed by each state government. Now, very often, you had those appointments were not made by state governments. Even if they were made, the kind of cases that went to them were very few, because very few people even knew that this regime existed. Primarily, the kinds of cases that were going to them were where banks were like basically losing people's money as a result of fraudulent activities carried out by somebody, right? So largely it was around financial loss and financial harm. Those kinds of cases were going, but purely, personal data breaches, those kinds of privacy matters were not going to these courts and tribunals. Right. The other bucket of cases that the courts were largely dealing with were, privacy intrusions by the state, right? So, for instance, like the Aadhaar case is a good example of something that happened in the interim period, right? And there's a third bucket, which is basically cases where there's individual against individual. So, for instance, I think one of the very prominent ones in the last 4-5 years is how there's a Delhi High Court judgment on how an individual has a right to privacy against their own parents, where they had eloped and married another individual. So to coerce this person to come back to their parental home was deemed to be essentially a violation of their right to privacy, right? So it was these kind of facets that the courts and the government were basically engaging with at that point in time. So the mainstreaming of this whole idea of data protection, privacy, etc., is kind of in that sense a more recent phenomenon, even though we've had a longish journey in these kind of other aspects. So you're absolutely right in that this act is in that sense a watershed moment. It will probably change the way that both organizations and the state machinery think about the way that data is processed, right? And we don't look at it merely as some sort of a constitutional right battle or some sort of lofty debate about rights, but it's actually affecting our day-to-day lives and day-to-day data collection that is being impacted as a result of that.
And Thomas, you mentioned in 2017, I think that things also come up, and many times I have read up about the DPDP Act, the Puttaswamy case.
Yeah.
So it seems like a milestone.
It does.
In terms of the DPDP coming into picture. So what exactly was this case about? If you could shed light to our readers, what exactly was the story behind this man who fought for the privacy in terms of the Aadhaar scenario?
Yeah. So Justice Puttaswamy was a judge based out of Karnataka. Essentially, he. I think he had challenged the constitutionality of the Aadhaar scheme, right? So I think back then there was some, debate around how the Aadhaar information was collected, how is it being used, what are the safeguards that were available to individuals against the Aadhaar or in relation to their Aadhaar database. So I think the primary question that Justice Puttaswamy wanted the courts to engage with was the idea of whether the collection of Aadhaar information by the state was a breach of the individual's privacy. Because I think he viewed it as compelled collection of, for instance, my biometric information, because I'm providing my fingerprints when I'm enrolling to the Aadhaar or when I'm doing authentication, I'm also providing potentially my biometrics to the scanner at least, right? I'm providing certain demographic information like my address, my date of birth, etc. to the government on a what he viewed to be a coerced essentially basis, right? And the question that the court was really faced with was, is this a breach of an individual's right to privacy, right?
Okay.
But in order to determine that question, first, I think the court had to determine whether we do have a right to privacy, right? So this judgment in 2017 was basically the court taking categoric view that, look, all of the case history in the past aside, we are now emphatically stating that all individuals have the right to privacy and the right to basically be autonomous about information that they generate, who they are able to expose their personal lives to, who they're able to expose their private lives to. And that was a watershed moment because it also led to other second order consequences. So for instance, a large number of the principles that led to decriminalization of homosexuality, even for that matter for decriminalization of adultery and a whole range of other judgments, all derive from the same principle that I have the right as an individual to ensure that I control how the state views my personal life, views my private life, state or other organizations view my personal life, view my private life, and I have to be in autonomous control over, of complete control over what information I am able to let out into the public domain. Now, of course, there are some exceptions to this rule because, for instance, if I'm being investigated, I cannot say that I'm not going to give you my personal
Obviously.
information.
Right.
So there are some common sense exceptions to that rule, I think. But by and large, the 2017 judgment was a great way to lay down this principle kind of emphatically, because after this, there's not going to be any debate in terms of do individuals have this right or not.
There's not going to be any subjective,
correct,
because you have something that's laid out and everybody needs to adhere to that.
Exactly.
I mean, it's quite interesting. Like one man's fight, led to such a moment. And so, Thomas, my next question is now obviously, it's very good that you bring up some of the other non-tech cases where we are asked to give out data. I think you mentioned the pharmacy, scenario. I think when you're in that tech world, you only think about social media apps and all of that. So thanks for bringing that up. So now look, now that the rules are going to be enforced, now I see a consent form when I log into any app or something. How will the government ensure that the company or the entity is handling the data in the way that it claims to do so to the user? Is there any body that the entity needs to report to, where they will be liable for investigations from that government body? Or is it in such a way that if I suspect that this app is not handling my data carefully, only then I can approach the government or my courts and ask them for a thorough investigation? So how does that ensuring that this thing is being enforced gonna
Actually, you touch upon a very interesting aspect, Supreet, because I think, and like I was saying earlier, the enforcement muscle behind the old rules were probably why it hasn't seen as widespread adoption, or it hasn't seen as much success as perhaps this act is going to have. Thankfully, I think the enforcement muscle here is a little bit different, right? And I think it starts at the very first instance when you have a interaction with a social media app or with any app that's collecting your data or any organization. So the first thing that you have to observe as an individual is in that notice that is being provided to you, they are required to give you mechanisms by which you can complain to them, or they're required to give you mechanisms by which you can enforce certain rights against them. Right? So what I would do, for instance, is if I were the individual, I would look for what are the mechanisms in which I can raise, and what the Act calls them grievances. What are the grievances that I can raise in relation to a particular app, and who do I raise it to, right? So that's my first port of call, right? So if I suspect that an app is doing essentially or misusing my data, or is not processing my data in the way that I think it needs to, I can basically go to that particular grievance mechanism and raise a grievance complaint in relation to the processing of my data. And they're duty bound to respond to you within a certain time period. Right? Now, if that response is unsatisfactory, then the matter gets escalated to something called a data protection board, right? Which is an enforcement body that's being set up in India for the first time to police the Data Protection Act and its compliance.
Okay, so it's going to be a separate body.
It's going to be a separate body, correct. So the Data Protection Board then has the right to investigate each organization for which it has received a complaint, and the fines can go all the way up to 250 crores that they can impose. So it ranges between 50 crores to 250 crores. Now, the one, thankfully, comfort that some organizations can take is that the government is not looking to wrap every small kind of non-compliance on the knuckle. It's kind of looking to penalize significant contraventions of the act, right? So I think the government itself recognizes that there's going to be some teething kind of issues for the first couple of years, and so significant non-contraventions are what are going to be penalized. But if you do end up in a significant non-contravention and the board catches you doing it, the fines are between 50 to 250 crores.
Okay.
There's a small subset of organizations called significant data fiduciaries,
right,
who are subject to a higher burden of duty, right? So they are required to do data protection impact assessments, audits, they're required to appoint a local data protection officer, and so on, where the compliance or the enforcement is more proactive in that sense, right? So these are likely to be large social media companies or anybody who has the ability to kind of process large volumes of data, or their data processing activities involve a large data footprint or large impact. So expect perhaps, the largest of the social media companies to get covered. Perhaps other kind of novel processing of data where there's a high impact on the data processing. Genetic data perhaps would be one of those other things where you could expect some sort of movement on this front. So the government is thinking about it. It is segmenting those kinds of small pockets where this information is deemed to be a little bit more critical, and therefore there is more proactive compliance. But by and large, generally it's a little bit more reactive, right? You, the citizen, are in control over when you want to essentially initiate a complaint or figure out whether you really want to go against a particular organization.
Right. It's interesting about the significant data fiduciaries aspect. I think we all on a day-to-day basis access these apps and services that process high volumes of data. Take AI only for example. I think the amount of personal data that we share with chatbots is quite insane. So, but if I'm not wrong, the government has still not exactly defined what these significant data fiduciaries are, and to what higher extent will they need to safeguard the data and all of those things. So how do you think this is going to pan out? Will they be mandated to localize the data in India, or where is the ceiling for these significant data fiduciaries in terms of maintaining the privacy?
So this actually has two aspects, right? Who they are and versus what they do. I think there's a little bit of different clarity in terms of both these questions. Who they are, I think currently we only have subjective factors in terms of, what is the volume of data that they process, what is the impact of the data processing, and so on. I think there, at least, thankfully, the government has laid down the parameters that it wants to consider. I think that can give people who are a little bit familiar with the industry a fair set of idea of who it's likely to cover. Big social media, definitely, I would think. Right. Kind of like I mentioned, the more critical processing of data, genetic data, etc., very likely to get involved. Anybody that has impacts on India's electoral democracy, right? Those kind of entities perhaps probably covered, right? In terms of what they are required to do, I think there's a little bit more clarity there, because like I was saying, they are required to do data protection impact assessments, they're required to appoint a data protection officer, and so on. On the localization question, I think there is basically the government is not clear about what pieces of data these guys are supposed to localize, but there's an intent to say that, look, there is some pieces of data that they have to localize. So I think that thinking is still evolving in terms of figuring out, which pieces of information, even by big tech, is required to be localized, or at least subject to additional protections, if nothing else. So yeah, I think on that front, we don't really have as much kind of clarity yet as we would have required, but there is significantly more than who is going to be covered and so on. So yeah, I mean, expect, I think, some of their operations and their posture towards data to change a little bit, to actually kind of take the Indian market with some deliberate kind of compliance with respect to some of these measures, because I think other than, unlike in the older regime when we didn't have anything specifically for them, I think we have now a set of laws that has the ability to treat these guys slightly differently and ensure that there's a heightened compliance for them.
So Thomas, my next question is, of course, we live in a free world. Anybody in any country can develop an app, and I can sit in India and use the app. So how do my rights apply in that situation where that application has nothing to do with India or the government except for the fact that it provides services to me?
Yeah.
And that country has, let's say my data is stored in that particular country and their data privacy rights are a little loose, or in the worst case non-existent.
Yeah.
Will the app developer, whether it's an individual or an organization, is liable to the DPDP Act that's in India, even though he has no presence in India except for the fact that there's like 2-3 users using the app? How does that situation play?
Short answer, yes.
Okay.
Complicated answer is not really.
Okay. If you could pick any example.
So let's say there's an app that's sitting out of China that's digital lending in India, right? A classic example of the one that everybody's kind of afraid of, I think. If you are providing any goods or services to a citizen or to a person resident in India using a digital platform and you're processing their personal data, the act applies, right? It's very categoric about the fact that it applies to you.
Okay.
Right? So all the responsibilities, obligations, etc. that we discussed, theoretically all these other companies are required to comply with them, right? But the secondary question is, how do you really police some of these things, right? So if there is an organization that does not have a presence in India, it's, for various reasons, and not just under the data protection legislation, but even under conventional kind of other laws, it's quite difficult to police some of these entities, because unless they are physically located in India, there's very little that you can do by way of coercive action on these kinds of entities, right? So what I would say is, in all of these circumstances, you as an individual take an organized call, right? Or take an informed call rather, in terms of who you're providing your information to, right? Is this a brand you trust, or is this an entity that you trust?
Right.
Because the moment somebody's sitting overseas, while theoretically all of these protections do apply, and if they're a compliant organization, they will comply with all of these. They will agree to India's laws. They will comply with India's laws. But there's no real tangible way, unless you take some certain extreme measures, for the government to really coerce them into doing any of these measures. Right. Now, we've seen these extreme measures being taken for entities that otherwise operate a business presence in India. Like, for instance, if I have an R&D unit in India, there are coercive measures that the government can do, even if my actual platform is not offered by that entity. But if I'm entirely sitting outside the country, I have no presence in India, no assets in India, etc., it's very difficult in that sense for any tangible enforcement action to be taken against these companies. So I would suggest that the same methods of caution that you already exist in or already exercise in relation to some of these organizations, continue to do it. I would say, right? Because I think this law in that sense is only marginally beneficial for you in relation to some of these entities. Now, of course, the one advantage that the law has is, if there are specific classes of entities who do significant activities, they may end up being classified as significant data fiduciaries, and as a result of that, localization restrictions may apply to them. The other key bucket is, the government has the ability to notify a blacklist of countries for which data may not be transferred to, or there are some significant restrictions to the transfer of data to those countries. There's a 50-50 chance that China may be on that list, right? Given the geopolitical climate at the given point in time when the list comes out, I think at that point we'll know. But the more, I think, egregious kind of countries where a lot of international business isn't done, definitely expect those countries to be on that list. So I think these are the only two other levers that the government has in terms of trying to protect you from that. But short of this, I think the marginal kind of protection that this act really offers for that, I would say is kind of minimal at best, I would say.
Right. Now, my next series of questions is about a few examples. As they all say, we learn best through examples.
Sure.
I'm going to give you a few real world scenarios so the viewers can also understand what is exactly at stakes.
Yeah.
So now let's say I post a picture of mine on a social media app. There's another individual account on the same platform that takes my picture, does a deep fake of it and puts it out.
Yeah.
Now, how does the Protection Act or the privacy laws apply in this scenario? What rights do I have as a user currently residing in India?
This is a complicated one, Supreet, only because I think, Indian law exempts any information that you have voluntarily put out into the public domain from the applicability of the act itself. So if I have a public profile where I've put up a photograph, I think unfortunately under the Data Protection Act at least, right, this processing of that particular piece of information is not really covered, and there aren't boundaries around what can I really do with that information. Is it originally linked to the original purpose by which I put it, and so on. Deepfakes, I think, are an issue that is being dealt with on the IT Act side, right? So we have something called as the intermediaries regulation in India, or the intermediaries guidelines, and the government has recently put up a draft set of amendments where they've required all synthetically generated content to be labeled as such.
Yes.
Now, I may have a difference of opinion with the government on whether it actually is going to work or whether it's meaningful in any form, right? But I think locating these kinds of harms or trying to solve these kind of harms through privacy law may not be the right kind of way to think about it, at least in terms of us as an individual. Definitely, if there's a deepfake which causes you harm, there are other methods by which you can solve it. So, for instance, if it is causing you, if it's defamatory to you, you can always approach the police station. In fact, because defamation is a criminal offence under Indian law. If it is sexually explicit material, again, subject to, of course, all the sensitivities that we have in India, there are law enforcement mechanisms. There are courts that actually engage with this kind of a mechanism. So the average individual, in that sense, has some of these other additional protections, but unfortunately, I think the Data Protection Act doesn't, delve with this particular kind of a example, because publicly available information is exempt under the Act.
Right. The next scenario is, let's say, on a cloud storage service.
Yeah.
It's governed by a big tech company, whatever. So now, let's say someone transmits a malicious file where someone unknowingly downloads it and it extracts their personal data, whatever, in a very malicious intent and a way. Now, who is going to be held liable and responsible for this? Is this the company that failed to do its responsibility in terms of verifying each and every file that was uploaded onto its cloud storage service? Or is it going to be the individual who put out the malicious file?
So, again, this is another one where I think the Data Protection Act doesn't give you much kind of protection, because what you're really describing is essentially kind of unauthorized access to my data.
Right.
It's actually already an offense under Indian law.
Got it.
So we have an Indian IT Act that actually already protects you against something like this. In fact, it's a criminal offense that carries about 3 years of imprisonment, if I'm not mistaken. So it is unfortunate that our police system is still kind of catching up to some of these offenses. But there are actually and in fact, the Bangalore Cyber Cell Police, thankfully, is very well attuned to this. Bangalore, Hyderabad, etc. They're very well attuned to this. They are, I think, the criminal remedies are actually, I think, a little bit more easily accessible on some of these things. On the question of, the data breach itself and who is responsible, this, especially if there's one malicious individual who has transmitted a malicious file through the internet, unfortunately, I don't think the law deems the organizations, either of the organizations, either the cloud service provider or the individual's organization itself, to be responsible. It is likely going to be treated as essentially an individual's act of non-compliance. So in that kind of particular example, I would think that data protection law really doesn't give you that much of a benefit. But having said that, and just, generally speaking about organizations' responsibility to prevent malicious content on their services and sites, the Indian Data Protection Act actually lays down about 7 or 8 principles in terms of what security measures an organization must put in place for any data that is processed by them. This includes things like, maintaining access logs, ensuring that you're able to detect breaches on a real-time basis, that you're able to continue to track the harms that data breach has caused, ensuring that, all industry best practices are followed in relation to your security practices, etc. So there's already a more proactive posture that the government is expecting you to exercise. So I think how the government is viewing that is, at least it's looking at it more as doing these proactive things may ensure you it's prevented that you get download from these malicious files and so on. So as a result of which, I think they're hoping that those proactive measures will prevent you from ultimately being in a place where this kind of stuff is prevented. But otherwise, there are general remedies that are available under other Indian laws in relation to some of this stuff.
And my next scenario would be like, let's say there's a government scheme for let's say someone who's under the below poverty line segment. Now that scheme, hypothetically, it mandates you have your BPL card, and if you want to avail the scheme, I'd also want you to give your Aadhaar for it. Now, can the citizen pose the question to the government, look, you have my BPL card, which clarifies that I am fit to get this service, but why else would you want my Aadhaar? So how would this come into the picture in that sort of a scenario?
I would say yes, but not under this act, because this act gives the government the ability to process data for government subsidies and schemes without having to get consent from the specific individual.
Got it.
But there is an actual, this is exactly the same question that somebody asked in relation to Aadhaar, right? Which is, why must I provide my personal information to the government? Yeah, exactly. Because back then you had a ration card, if you were BPL, you had a BPL exact documentation, you had your passport, your driver's licenses, you had voters' IDs, you had a plethora of other identities that you had, right? So the natural question is, why one more? Right? Or why must I be compelled to provide biometrics for one more? Right?
Exactly.
And that's exactly the question that was asked to the government in relation to each of these pieces of information. So every citizen has the right, by way of a constitutional court case, to ask the government, which is, why are you processing this additional piece of information? And the government is actually required to demonstrate that it is the least intrusive method of achieving a particular outcome. Right. So, like for instance, in your example of, let's say I wanted to distribute benefits to certain classes of people, and they already had an identifier that existed.
Exactly.
The government is required to show you in that court case why another identification is required when the existing one could have very well served the purpose. Right. So it has the need to show you why something is, or some additional measure is, the least intrusive method to achieve something.
Right.
So, these protections exist, right? I think as a citizenry, we've engaged with it in some time in the past, but I think unfortunately not enough, perhaps. So I think that's definitely something that I'm hoping will pick up over the next couple of years. As a citizenry, we're getting aware of the rights that we have in relation to our data. We're treating our data as a real extension of ourselves and our human bodies, right? And that requires us to be, I think, holding the state and other companies responsible for all the choices that they're making, and there's enough avenues, I think, to do that. So I think that's definitely something that I'm hopeful this act and these kind of legislations and cases will allow our citizens to do.
So Thomas, my last question would be about along the same lines of the previous discussion about the RTI Act. Obviously there's a lot of information that a citizen in India would want to ask the government. But what if the information is deemed as private or personal information, so that makes the government easier to withhold that information under the DPDP Act? So how do these two regulations overlap, and how do you address the confusion that many citizens are having?
Yeah. So Supreet, on this front, I think this is one of those places where I think the government has assumed a little bit more power unto itself by using this law. Earlier, the RTI Act already allowed for an exemption for personal information, but what it allowed each individual government office to do, or each individual entity that's subject to the RTI to do, was to take a call in terms of whether a public interest is served and so on in disclosing that information, despite it being personal information. This act has basically introduced an amendment, or has amended the RTI Act to the effect of saying that any personal information is now straight up may be rejected by the specific office. So as a result of which, what we've now ended up with is a situation where the RTI mechanism is potentially a little bit more weaker, because it gives the government the ability to say no in more instances than it would have been able to in the previous iteration of the RTI Act. So I think as a result of which, I think expect a few more RTIs, you expect a few more rejections to your RTI requests, especially where there are personal details involved, bribery and those kinds of cases, etc., where if people investigating those kinds of cases may see a lot more drop off of RTI requests in relation to requests that they make. But yeah, as a result of which, this act has now therefore weakened the RTI mechanism a little bit.
Right. So Thomas, thank you so much for the a detailed conversation, and thank you for taking the time out on a busy weekday for explaining our audience what the DPDP Act means.
Thank you, Supreet, and hopefully you guys also learned something today. And I'm hoping that as a result of this act, we're able to come to a place where we're actively engaging with our digital rights. Because to my mind, this is just the first step towards being essentially or setting up the right regulatory infrastructure for us to be a responsible digital economy. And I think there's miles to go there, and I think this is a very first step, and it's a great first step. And I'm hoping that all of us really engage with our digital rights as we go forward. And thank you so much for having me. It was a great conversation. Thank you so much.
And thank you to all of you for listening to the conversation. As Thomas mentioned, I hope we take multiple steps towards this direction. So stay tuned for more such conversations like these. Like, share and subscribe to AIM Network, and always remember to think AI and think AIM.